Hi, my name is Pamela Tan. I'm a volunteer attorney with Administer Justice, and today we are going to talk about debt collection. We're going to cover today 2 points. The first is going to be, what can you do before you end up in court? Second, we're going to talk about your rights under the law. First, what are the steps you need to take before you end up in court? If you know you're going to miss a payment, oftentimes people want to stick their head in the sand and not think about it. But it actually may be better to act proactively and call your lender. There are many ways that you can negotiate payment plans or simply explain the situation to them to see if they can offer other options, such as no interest payments or the ability to not make payments for a couple of months until you get back on your feet. If the collectors are coming after you at this point and you're receiving calls and letters for you to make payments, another option that you have is to send what is called a cease letter. In this letter, you are explaining why it is that you cannot make payments, any rights that you have under the law to not make payments, and asking them to cease their collection behavior. If this cease letter does not work, the next option that you have is to meet with an attorney and ask them to send a letter on your behalf. Oftentimes, this will actually get the debt collector to stop contacting you. If your debt is overwhelming, and by overwhelming, usually we mean more than $10,000 in debt, you may want to explore the option of bankruptcy. Now, a lot of people feel uncomfortable with bankruptcy, but it is something that exists under the law to help you if you are under overwhelming debt. So again, we recommend that you consult with an attorney to see if bankruptcy would be a good option. The moment you file for bankruptcy, all debt collection action must cease. So this is also a way to get out from under all those phone calls and letters that are coming in. Our second point is, what are your rights under the law? When we talk about the law, most oftentimes people are talking about the Fair Debt Collection Practices Act. Now, this law only covers debt collectors. What are debt collectors? Debt collectors are companies or agencies that have bought your debt from your original lender. So for example, let's say you have a credit card with Capital One. You owe them money, so Capital One decides they're not going to sell your debt to a debt collection agency. For example, Midland Funding. This Midland Funding is now considered a debt collector because it is not the original owner of the debt, but has bought the debt from somebody else. Under the Fair Debt Collection Practices Act, debt collectors are prohibited from engaging in harassment and abuse. So what is covered under harassment and abuse? Harassment and abuse include threats of violence, causing the telephone to ring repeatedly or at odd hours, and engaging in obscene language. So threats of violence would include, for example, if they're calling and they're saying that they're going to harm you or someone you love, or they're going to send someone to knock down your door to get the money from you. Causing the telephone to ring repeatedly would be, for example, if they're calling you and you don't pick up, so they hang up and they just keep calling and hang up and calling repeatedly, and this is a form of psychological abuse. They may also call at odd hours, for example, at 2 a.m. in the morning, waking you up and scaring you into trying to make some payments. So what's considered reasonable hours under the Fair Debt Collection Practices Act is generally between the hours of 8 a.m. and 9 p.m. So if they're calling before 8 a.m. or they're calling after 9 p.m., you should document that because that is actually considered harassment. Lastly, they're not allowed to engage in obscene language, which is pretty self-explanatory. The Fair Debt Collection Practices Act also provides some privacy protections. One is the debt collector is not allowed to communicate with third parties. So, for example, they can't be calling your neighbor or your mother asking you where you are and asking them why you haven't made any payments. Also, they can't be communicating with you at an unusual time or place. So place might include, for example, your place of employment. They can't call your boss, they can't call your workplace, letting them know that you owe money and asking where you are. Lastly, if you send a cease letter, they must cease all communication at that time. Again, if they fail to do so, that's when you may want to contact an attorney and ask the attorney to send a letter on your behalf. If the cease letter by itself does not work, usually a letter from an attorney will stop this behavior. If you believe you have a claim under the Fair Debt Collection Practices Act, please contact Administer Justice by calling the number below. Thank you for your time. We hope you found this information helpful. God bless.